Good afternoon.
Good afternoon.
Good afternoon, Your Honor.
Okay, so I see that we have a court reporter. So I'm going to go ahead and call the case and put us on the record. Madam Court Reporter, we are here on a hearing regarding the case of Belomo versus Avion Systems et al. Specifically, we're here on the motion of Tech Mahindra to recover attorney's fees under 91168 in case number 2017CV292635. I'm gonna sort of outline where I think we are procedurally and then figure out what the lay of the land is as far as the parties understand it. This matter, the court ultimately dismissed the claim against Tech Mahindra, which was for civil conspiracy. That decision was affirmed on appeal. The Supreme Court denied review of that decision by the Court of Appeals, and so it was remitted back to me. I am aware that Tech Mahindra filed their motion for fees slightly before all of that formal paperwork happened, but once it happened, that motion became ripe. Ms. Meyer responded to it on behalf of Mr. Belomo. And then in addition to sort of attacking the legal framework of the basis for entitlement to recover fees under OCGA 91168, including that the offer wasn't made in good faith, that the amount that they were claiming was unreasonable, and that the amount had not been itemized. Ms. Meyer, on behalf of Mr. Belomo, also requested an evidentiary hearing regarding the issue of the attorney's fees, specifically related to how that offer came to exist and the amount of attorney's fees incurred afterwards. So that's what I understand us to be here on. Is there general agreement that that's what we're here for today in terms of the scope of what we're going to undertake now? Ms. Meyer?
Yes, Your Honor.
Mr. Buhay?
Yes, Your Honor.
Okay. I'll also note that at one point, I did request that Tech Mahindra submit their billing records in support of that claim because it's substantial. I mean, it's north of, is it 1.2 million or 1.1 million? I don't remember the number exactly.
It's north of that, Your Honor. I think it's, and Mr. Robin can address this in more detail. I think it's 1.6 million in fees and 400 some odd thousand in expenses.
Okay.
So we're pushing 2 million.
Yeah, I knew it was really big. I'm just going to leave it at that because that was, I remember that there was a million behind the number and I went with that. I say that only to say that the number was substantial. And so I did request that Tech Mahindra submit in camera for my review the billing, because I do believe, separate and apart from this specific statutory scheme, that the case law generally supports the idea that the court is can essentially function as an expert when it comes to the reasonableness of attorney's fees as to both the work done and the rates charged. And so that had been my intention, but then Ms. Meyer helpfully pointed out that under 91168, she's entitled to a hearing. And so that's why we're here. Ms. Meyer, how would you like to proceed as to the evidentiary portion?
Your Honor, as the court prefers, I can go ahead and address the reasonableness or the fairness of the offer itself, or the court can hear about the fee invoices first, as the court prefers.
Okay.
Either one works for me.
Okay. The reason I ask is I have read the parties' briefing, and so I feel like we can dispense with the sort of overall, opening argument about what the parties' positions are. I'm very familiar with 91168 and its structures. And so I feel like I'm in a good position to start from there. And because you are the one that requested the evidentiary hearing, I believe you would have the opportunity to to go first, such as it were. Mr. Buhay, any concern or dispute about that procedure?
Yeah, Your Honor, I'm fine with that. I have probably gone a little overboard in I think there's certain facts that aren't in dispute. I'm prepared to prove them up though as necessary. I do want to make two quick points. First off, Mr. Morrison, who's attending this hearing, had given two affidavits in support of our motion. Both those affidavits relate to just establishing procedural facts that I think there's no dispute about. I think Your Honor can certainly take judicial notice about them. Mr. Belomo's newborn daughter did not keep up with his schedule, and she was born earlier this morning. But he's
that's
here.
so exciting. Congratulations, Mr. Morrison.
Thank you, Your Honor.
So he's tired, but he's here. And what I was going to suggest, unless Ms. Meyer has any reason to question him about any statements he made in his affidavit, I would, if it's with everyone's consent and approval, I'd ask that he be allowed to leave this hearing if it's acceptable to everyone.
Ms. Meyer?
Well, first of all, congratulations to Mr. Morrison. That's an exciting time, and he probably needs some sleep. So we are willing to accept his affidavit without cross-examination and relieve him from continuing to be here today if he needs to go be with his family.
Okay, excellent. Well, I think that allows you to be on your way, Mr. Morrison. And if you need to blame anybody to your new family, you can blame me for requiring you to be here. Good luck to you and congratulations to you and your wife.
Thank you, Your Honor. Have a nice weekend.
You too.
The other issue I had, Your Honor, we had filed a motion to file under seal two exhibits, one of which are the actual legal bills themselves. The Bates stamped copies, which have been shared with Your Honor and with Ms. Meyer. The other was what was our Exhibit 16, and it was some exchanges, and it had documents attached to it that were marked as attorney's eyes only in the underlying case. And I'm fine with however Your Honor wants to do it, but those are not officially in the record and that they haven't been filed.
I noticed that, and I apologize. I remember when I was reviewing the file in preparation for today's hearing, I saw the order. I remember the order being brought to my attention. I thought, and perhaps mistakenly thought, that I had said, yes, this is fine, go ahead and file it. But you were authorized to file it under seal. The court won't the clerk won't accept it without an actual order authorizing you to file it under seal. But the order that you submitted was fine, and it had been my intention. And as I said, my belief that I'd already done it, but certainly my intention to do it.
Okay, and once the order is signed, obviously we'll talk about these documents today, but once the order is signed, I can, I guess, file them under seal either this afternoon or Monday if that works with the court.
It does. Mr. Freehoff, do you have that proposed order?
Judge, I'll check. I suspect I do.
Okay. If there's any way that you can go ahead and file it now, assuming that you have it, if you can file it now and ask the clerk to expedite the acceptance of that order, I would appreciate it.
Sure. Just out of curiosity, was it sent in Word format?
Yes, sir. I can find that email, or
No,
certainly.
You don't have to. I can find it. No
Okay.
problem. I will pop in and confirm that it has been e-filed and expedited as soon as I can confirm that.
It was on, the proposed order that I'm looking at was sent Thursday, so yesterday at 9 o'clock, and it's an Adobe PDF, but I don't really think it matters. I remember looking at it and it was acceptable, so.
I think, Mr. Freehoff, I sent it according to my email at 9:21 yesterday.
Okay.
Yep.
All right. I'm on it. I will confirm when it's done.
Okay, thank you. Okay, so thank you for that, Mr. Buhay. I don't believe, other than perfecting your record, the parties are in possession of the necessary materials, correct?
That is correct.
Okay, Ms.
Yeah.
Meyer?
Yes, I did have one question about those documents. There were some fee invoices that I wanted to actually point a witness to, and I guess Mr. Robin to, and ask him some questions about. So would the court prefer that I simply reference the Bates number and leave it to counsel and the court to look at them without me putting them on the screen, since this is a publicly available feed, or do I need to actually put it on the screen as I normally would with an exhibit?
Yeah, it's entirely up to y'all in terms of your comfort level. And essentially it would be Mr. Buhay and Mr. Robbins' right to assert that. I mean, I doubt anybody's watching because we're all pretty boring. And this is a pretty boring case, but technically we are being live streamed on YouTube. My video live streams are not retained, and so it wouldn't necessarily be available, long term, but it is technically available live stream on YouTube as we speak. So you should take that into account if you are using or referencing matters that have otherwise been asserted as confidential, number one. Number two, I do have the documents. They are page numbered. And so to the extent that you can reference them, I think that we should probably be able to navigate it fairly easily that way. And if we have any trouble, we'll see if we can work around it.
All right, thank you.
Excellent. So last thing is Ms. Meyer, when I said I was going to start with you and you indicated, do you want to go with, where do you want me to start? So I think, as I understand it, for purposes of the evidentiary presentation that you might make, that the fundamental challenges that you want to assert is that the offer itself wasn't made in good faith. And that even if the court were to decide that the offer was made in good faith and that Tech Mahindra was entitled to attorney's fees, that the amount they're seeking is unreasonable. Is that a fair assessment at its most basic?
Yes, Your Honor, it is.
Okay. And so as far as I'm concerned, to the extent that you can attempt to inquire on both of those issues at the same time with different witnesses, you're free to present it in any manner that you think is most efficient and most persuasive from your client's perspective.
All right. I will get started then. Unless there are other preliminary matters the court wanted to.
I don't think so, unless y'all had any other preliminary matters.
I have nothing else.
But we have nothing else, Your Honor.
Okay, well then go ahead, Ms. Meyer.
All right, so I'd like to call Philip Robin on cross.
Okay, Mr. Robin, will you raise your right hand, please? Well, first you're muted, so can you unmute?
Still muted.
It's been 3 years and it's still not a Zoom hearing unless at least one time you have to say you're still muted. Mr. Robin, do you swear that the testimony you're about to give the court will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. You may lower your hand. Go ahead, Ms. Meyer.
Before we get into substance, I had a little bit of difficulty hearing Mr. Robin. Perhaps he could get a little bit closer to his microphone.
Let me see what I can do here.
Okay, I can hear you now better.
How's that?
That's much better.
That is better.
Okay.
Thank you. So, Mr. Robin, you have been lead counsel for Tech Mahindra Americas Inc. at all times during this litigation, correct?
That's right.
Okay. And can we agree, when I say Tech Mahindra, I'm actually referring to Tech Mahindra Americas Inc. All right?
Yes. Okay.
Thank you. Now, during this lawsuit, you were aware that Giacomo Bellomo, my client, had a judgment against Avion Systems Inc., correct?
I was aware of it once we had the lawsuit, yes.
All right. And if you'll bear with me just a moment. Sorry, Your Honor, I thought I had loaded all of my exhibits, and it appears that I had not loaded all of them. All right. So this is the judgment that you were aware of, correct?
Yes.
Okay. And when you add up the contract damages and the attorney's fees, you get to almost $305,000, correct?
That looks right, yeah.
Okay, and so the judgment was entered January 12, 2015, and by the time this lawsuit was filed and served on Tech Mahindra, it had been about 2.5 years since this judgment had been entered, with post-judgment interest accruing for those 2.5 years.
I suppose, but I learned of the judgment based on the complaint at first. It was a while before I actually saw the judgment itself.
All right. Now, Tech Mahindra was actually served with the complaint in this case on July 18, 2017. Does that sound correct?
It sounds correct because I know our local council secured an extension, and I think it went to around the middle of the month, so that sounds about right. The 30-day extension went to the middle of the month.
Let's be just 1 second. Okay, and that's the sheriff's entry. So it was e-filed July 27, 2017 with the court, correct? Served on the 18th and e-filed on the 27th.
I don't know that I've ever seen this before, but I mean, it seems correct. I remember that the response from Tech Mahindra was due sort of in the middle of August, and we negotiated a 30-day or thereabout extension of time with you, and that brought it to the middle of September, so the timing seems to work out.
Okay, so you requested that Ms. Lewis reach out to me and discuss an extension of time.
That's right.
Okay. And ultimately, the answer to the lawsuit was filed by you and with Ms. Lewis's law firm's assistance on September 15, 2017. Does that look correct?
I don't mean to interrupt I understand lawyers, they have thoughts about how they want to present things, but I mean, all of this is in the record. To the extent that you want to know what Mr. Robin knew, I understand that. But I mean, the record shows that these things were filed, which document sort of dispositively for all of our purposes when these things occurred. And so it feels like these are some preliminary matters we can skip ahead, but go ahead, Ms. Meyer.
All right, thank you, Your Honor. Just setting the stage and I'm moving on. So now, after service in July and before this September 15 answer was filed, you and I had a phone conversation on September 6, 2017. You recall that?
That sounds about right. And I recall that it got interrupted by a technical problem. I think a cell phone went out or something like that.
Right. And so we started out by phone and then we continued by email. Does that sound right?
Yes.
Okay. So before the phone call was disconnected, we were discussing, were we not, the merits of Mr. Bellomo's claims against Tech Mahindra, correct?
I remember telling you that we had a view of the case that it didn't have merit, and I remember saying that we thought that it was an arm's length transaction, and that we were. I don't remember if I did this in email or if it was on the phone call. I remember saying that we would be willing to share with you, or I could talk to the client about sharing with you the documents from the underlying M&A transaction, and we thought that might be a step towards resolving the case.
I raised some specific questions, such as I asked you about the decision to form a new entity versus simply having Tech Mahindra invest directly in Avion Systems. You remember that?
I don't specifically remember that, but perhaps you did.
And we had a discussion about the timing of the transaction, close in time to the 2015 trial that resulted in the entry of that judgment we just talked about. Do you recall that?
I don't, but that would have paralleled the allegations in the lawsuit.
And you recall me telling you that I needed to see some documentation about your contention that this was an arm's length transaction before I could consider recommending that Mr. Bellomo think about dismissing Tech Mahindra.
I do remember something like that. I remember you saying you had testimony from Ms. Rahman about the transaction, but that you didn't have transaction documents, and that you would be interested in seeing the documents from the Tech Mahindra side, which I think might have been why I said I would look into whether or not those could be provided.
Then after we got disconnected for whatever reason, I followed up with an email to you, correct?
Yes.
And that was this Exhibit 4 that I put on the screen, correct? Do you recognize that?
Reading it. Yes.
And so I notified you in this email that I did not have the actual deal documents, right?
Yes.
Okay. And then I asked you to actually provide me with copies of those documents if you thought that they would help me understand why, in your view, I should recommend that Mr. Bellomo agree to dismiss Tech Mahindra from the lawsuit, right?
Yes. So you're asking me to start discovery early, is how I read this.
Right. And I assured you that I would agree to confidential production of the documents if that was a concern, right?
Yes, but it was the fact that you were asking for it as discovery that was concerning.
Well, but you had told me that you thought those transaction documents would convince me of Tech Mahindra's viewpoint, correct?
Correct, but we also had a belief that Tech Mahindra wasn't subject to personal jurisdiction in Georgia in this case, and so we had a concern that by participating in discovery, we'd be waiving that defense. So we were willing to give you the documents, subject to whatever confidentiality provisions we needed to adhere to under those documents, but we didn't want to engage in discovery and potentially waive a defense.
And that personal jurisdiction defense has subsequently been rejected by the Georgia Supreme Court, right?
It was later rejected by the Georgia Supreme Court, but the case that definitively ruled on that argument was only just decided by the Supreme Court in Mallory versus Norfolk Southern Railroad this past June.
So you're talking about the U.S. Supreme Court now, not the Georgia
Correct.
Supreme Court.
Correct.
So
The Georgia Supreme Court's decision in the Cooper Tire case was on cert to the Supreme Court in the Mallory case.
all right. So I sent you the email that we just went over, and your response this is the email that we've just gone over, and your response was that you would was this email Exhibit 5, correct?
Yes,
Right. And coincidentally, that's actually dated 6 years to the day before today, is it not?
it is.
Sort of an irony that I noticed when I was going back over these exhibits. So your solution, as it were, to providing these deal documents that I'd asked for and that you had offered to give me was that Tech Mahindra was going to require me to personally sign a non-disclosure agreement. And that's what you attached to this Exhibit 5, right?
It was a way of providing the documents that we thought would get you what you said you needed, and we thought helped to facilitate a resolution of the case that we didn't think we belonged in.
So you wanted me, or at least somebody with a name misspelled, but similar to my name, you wanted me to sign to agree to treat these documents confidentially under a non-disclosure agreement that would not be governed by this court. Is that accurate?
Well, I provided you with the non-disclosure agreement, but if you wanted to negotiate its terms, we certainly would have been willing to negotiate that, and I certainly do apologize for misspelling your name.
So, apology accepted. I had specifically suggested that we just enter into a confidentiality order governed by this court, governed by Georgia law, and adopted by this court. But this was instead what you wanted to use. Isn't that accurate?
That is for the reasons I explained earlier.
And so my response to you was this email Exhibit 6, was it not?
Yes.
Okay. And I pointed out that I would be happy to enter into a confidentiality order in order to review the deal documents that you had told me would convince me to tell Mr. Bellomo to dismiss the case. Correct?
Yes.
But the problem.
A protective order.
I'm sorry?
Yes, a stipulated protective order in the litigation.
But my objection to the specific NDA you had sent was that it wasn't going to be a court order, correct?
Yes.
It wouldn't be governed by or overseen by this court, but would instead be governed separately, correct?
Yes.
Okay. And if there were to be any issues under the NDA, those would have to be dealt with in New York under New York law, which would require me to consent to the personal jurisdiction of Georgia courts, even though the personal jurisdiction of New York courts, even though the litigation was here in Georgia, correct?
Correct.
And I also, under the NDA, would not be able to even discuss the documents you were going to give me with my client. I could see them, but I couldn't discuss them with Mr. Bellomo, which would keep me from being able to use those documents to explain to him why perhaps we should consider dismissing Tech Mahindra from the lawsuit, correct?
That's correct.
All right. And so I sent you this email on September 8, 2017, correct? You got it then?
Yeah.
All right.
I must have gotten it done.
And did you ever respond to that email anytime in September of 2017 to discuss some alternative way to accommodate my need to see the transaction documents in order to evaluate whether I should recommend that Mr. Bellomo dismiss the lawsuit against Tech Mahindra.
I believe what I did is I did respond to it. I don't remember the exact date sitting here right this minute. But I did respond to it, and I sent you some documents that were from the public record, lien documents, and then a document from the Delaware Secretary of State that had to do with that separate company that you mentioned a little while back, the separate company that had been formed. And I think the complaint had alleged that Ms. Rahman, Kanchana Rahman, had 100% control of that company. And this document, I forget what it was exactly, but I think it was a formation document that the Delaware Secretary of State had on file. And it showed that she didn't have 100% control. So it undercut a piece of the complaint, one of the allegations in the complaint. And so since these were publicly available and I could share them with you, I sent you those, and I remember saying, look, these I can share with you. Let me know if these would be something that would be, useful in facilitating a further discussion. And my recollection is that you wrote back, and I had made along the way somewhere here, I had made a $5,000 settlement offer, and you rejected that and said something along the lines of, no, Mr. Bellomo won't settle for anything less than the amount of his judgment, or something along those lines. That's my recollection.
So do you agree that when I sent you this September 8, 2017 email, you could have turned around and said, let's go ahead and negotiate a confidentiality order and get those deal documents in your hands so that you can then explain to Mr. Bellomo why those deal documents that need to be treated confidentially establish that Tech Mahindra should be let out of the lawsuit?
No, I couldn't have done that, because that would have risked waiving a personal jurisdiction defense, so that just was not acceptable.
Well,
I had offered an alternative that I thought was perfectly reasonable, and if there was issues with the exact language of the agreement, if New York law wasn't acceptable and there was some other neutral jurisdiction, perhaps we could have picked New Jersey. I subsequently learned that that's a place where Mr. Bellomo lives. It's also a place where Tech Mahindra is incorporated. Perhaps we could have agreed to that. There was other options, but I couldn't recommend to Tech Mahindra that it essentially risk waiving a defense. That just wasn't going to be acceptable.
why not have Tech Mahindra agree by special appearance to enter into a confidentiality order for the specific purpose of permitting me to review documents that might allow me to determine whether I should recommend to Mr. Bellomo that he dismiss the case? That would have preserved Tech Mahindra's rights, would it not?
I wasn't going to risk any of Tech Mahindra's defenses by doing anything like a special appearance or taking any steps that could potentially be used against them. And the notion that if I had done something like that and it would have worked out where we would have gotten out of the case and I would have convinced you, I think is just sort of farcical. I later found out that you had some of the transaction documents, and not only that, you had records from Fifth Third Bank that showed that you knew that this transaction with Tech Mahindra and Avion Systems was in the works months before Mr. Bellomo won his judgment. And it was mandated by an agreement, a forbearance agreement between the bank and Avion Systems that was long in the works before his judgment was even won. Avion Systems was insolvent years before he won his judgment. So nothing was going to convince Mr. Bellomo or you, I don't think. So, in retrospect, I think I made the right decision in just, not doing anything more than trying to give you some documents in the public record.
Your Honor, I object and move to strike to the extent that Mr. Robin has just attempted to testify regarding what I personally knew and when I knew it.
I think Mr. Robin was testifying to his perceptions and opinions based on what he personally observed in his interactions with in the case. And so I'm going to let it stand. Your objection is overruled. Go ahead.
Thank you.
I will take this opportunity to interrupt a bit and say this. There's not a jury here. This case was hard fought. It is over. And so relitigating and going back over issues about which I am certain these two parties will never agree and will continue to actively disagree. I don't think it's helpful, number one. Number two, I've seen the exhibits, Ms. Meyer, that you submitted. I've also seen the letter that you wrote in response to the offer that said, hey, I don't have the information that I need in order to assess the offer that you've made. I think that point's been made and that we can probably move on from it.
Thank you, Your Honor. I will be very quick with a couple of other points. So as of October 19, when Exhibit 7 was issued, the documents had not been, the transaction documents had not been provided by Tech Mahindra for my review. Is that correct?
Probably not. No.
Okay. And there had still been no agreement to enter into a confidentiality order that might have permitted Tech Mahindra to disclose confidential documents for me to take a look at, correct?
I think that's correct. No confidential documents from Tech Mahindra.
So did you by any chance ever take a look at Georgia law governing special appearances to determine whether it might be possible to enter into a protective order by special appearance and still preserve defenses such as personal jurisdiction?
Don't remember if I did or not, but in dealing with personal jurisdiction defenses in other cases, I've been very leery of doing that because it invites waiver. Because if you make a mistake, you can waive the personal jurisdiction defense.
That's based on your general perception, but not based on any evaluation of what Georgia law says about personal jurisdiction waivers?
It's not, no, it's not about Georgia specifically. It's just in dealing with personal jurisdiction issues in numerous other cases.
Would you agree that this order did not operate to preclude Tech Mahindra from voluntarily negotiating protective order or providing me with documents or information to evaluate Tech Mahindra's potential defenses?
This order did not, no.
All right. So this order was entered October 19, 2017, correct?
Yes.
Do you know the date of the Rule 68 offer that was issued by Tech Mahindra?
I believe it was October 23rd.
So it was almost immediately after this order was entered. Is that correct?
It was 4 days later.
All right. And so is it accurate to say that Tech Mahindra knew that there would be no opportunity for any discovery during the 30 days encompassed by the offer of judgment, given that that offer of judgment was sent out so close in time after this order?
No, I don't think that's accurate.
What's inaccurate about it?
I don't think we knew that.
So you didn't understand that with typically, well, let me start over. So discovery typically has a 30-day turnaround time, right?
Well, first of all, I don't know that we were even considering it, because we started considering making the offer of settlement long before this order was issued. But also, this order only ran until the motions to dismiss were granted. They could have been granted the next day. So we didn't know how long there was going to be a stay. And I think, in fact, the motions to dismiss were decided shortly after this.
Well, but my question is, when discovery responses typically have a 30-day turnaround time, did you not understand that since Rule 68 offers also have a 30-day turnaround time, sending out a Rule 68 offer just a few days after this order meant that there would be no opportunity for any discovery prior to the expiration of that Rule 68 offer?
I don't really think that I made that connection. Although if that was relevant to you or Mr. Palomo, I think we would have certainly entertained a request for additional time to respond to the offer of settlement, but we never got that.
Tech Mahindra finally did produce written discovery sometime after the date of this Palomo Exhibit A, correct?
I don't remember what day this was done.
So Palomo Exhibit A is Tech Mahindra's first responses to document requests, correct?
That's right.
Okay, and the date on that is January 8, 2018, right?
Right.
So Tech Mahindra didn't actually start producing documents until sometime after January 8, 2018.
I think that's right.
All right. Ultimately, Tech Mahindra produced over 13,000 pages of documents and discovery. Is that correct?
That sounds right.
And that included the signed transaction documents that I've been asking for since September, as well as drafts of those documents and emails discussing the transaction. Correct?
There was many documents, yes.
Right. And so that means that Tech Mahindra had in its possession, as of the date of the offer of the judgment, all of those 13,000 pages of documents that Tech Mahindra understood Mr. Palomo and I did not have, correct?
It had them. It didn't have them all collected up to be produced. It had the transaction documents, the deal documents, the finals. It didn't have all of the emails and all of that all collected together and reviewed to be produced, no.
But Tech Mahindra did have the documents.
Well, of course.
And those are the documents that allowed Tech Mahindra to evaluate Tech Mahindra's potential liability and potential financial exposure before it issued its Rule 68 offer of settlement, correct?
It didn't need all of those documents to evaluate it. It knew its conduct and it knew what was in the public record, and it was able to base the $10,000 offer of settlement on just those.
So let's talk about the fee invoices. Unless you request otherwise, I will simply direct you to Bates numbers and allow you to pull up the documents yourself rather than you put them on the screen. If you would go
To the extent that we're going to do that, Mr. Robin, do you need to take a minute to actually access that document and have it in front of you?
I have them printed out, so I should be okay.
Okay.
Right. And I'm sorry, I didn't mean to interrupt the court.
That's fine. I just said, go ahead, Ms. Meyer.
Oh, thank you. I will say that I did find these are a little bit out of date order, and so I may have to skip around Bates numbers in order to stay in date order. If you would go please to Bates 13849.
I'm there.
Okay, so this is an invoice from December 12, 2017 from Kelly Dry and Warren to Tech Mahindra, correct?
Yes.
All right, and this is, as I understand it, a part of Tech Mahindra's Exhibit 1 for this hearing. Is that correct?
Yes.
All right. All right. So during the month of December 2017, the primary activity for this case was to prepare a 4-page status report to the court, correct?
Let me take a look. It's not just a status report. There's other things dealt with here.
Well, there are references to review of draft of court status report. That was on November 24, 2017, correct?
Yes.
Okay, and the next entry also that date references an email concerning a draft of the status report. Correct?
Do you mean that the 24th, the time entry that I put in?
Yes.
It does reference a draft status report, but it also references emails and a telephone call to discuss discovery generally.
So this 4-page status report that was prepared during that month, just simply, it's a standard court form that identifies the parties, general issues for discovery, basic procedural information, correct?
I will take your word for it. I don't remember exactly what it was.
Right. There was also a half-hour teleconference with Judge Markle to discuss the status report among all counsel. Everything could be dealt with by Judge Markle in all of half an hour on this status report, correct?
Where are you looking? I don't see a half-hour entry.
Let's see. Okay, on Bates 13851, there are references on November 30, 2017
Right.
to both you and Mr. Morrison entered time
Right.
for a status conference with the court. And Mr. Morrison, for example, who was under your supervision, only billed 0.8 for both talking with local counsel Jonathan Poole and preparing for and participating in that status conference, and then talking with you about strategy. Less than an hour for that conference. Correct?
Yes, that looks right.
All right. So my question is, if the month of December was devoted primarily to drafting that status report and attending a less than 1 hour conference with the court, why did it require $14,292.13 in fees and expenses to do that status report and show up for a half-hour hearing with the court?
Well, I think that I answered that because I told you it didn't only involve that. It didn't only involve the status report. There's other things here that we did. So those other things are also involved. And also, I will note that there's pieces of this that have been redacted away because they were outside the period. And the time that we have claimed for is not this full 12,000. We've only claimed for the amount that is associated with the actual time entries that are visible.
So is it your testimony under oath that the total that has been reported to the court has subtracted from it the portion that is redacted on this and other invoices?
Yes. We didn't alter the invoices other than to redact the time entries that weren't in the period.
But you're certain that the total reported to the court has the redacted portion subtracted?
Yes.
So let's go to Bates 13922. Just please let me know when you're there.
$13922. Yes.
So there's an entry for professional fees of $15,351.96. Do you see that?
Yes.
I've not been able to find anything in the record that explains what those professional fees are. Can you tell me what they are? Why they're not itemized?
Let me see if I can shed some light on that.
Ms. Meyer, while he's looking at that, could you tell me again that page number, please?
Yes, Your Honor, 13922.
Thank you.
So I think if you look at Bates number 14273, 14275, you'll see there's an invoice from the Strickland Rockland Lewis firm that covers that. The way that we had done local counsel or Georgia counsel is they sent their invoices to us, and then we paid them, and then passed them on to the client as an other charge, so that the client would only have to pay one bill for the case per month.
So, with me, please. So, would you go to Bates 13953, please?
Yes.
Can you tell me what the $4,092 in unexplained professional fees is on that entry?
Well, I don't see an invoice in the production that covers that, but my belief is that it's a one or more Strickland, Brockland, and Lewis invoices.
So if there's not an itemized invoice, there's no way to know what services, if any, were performed to explain that fee. Is that correct?
I don't see one in here, sitting here right now.
Would you turn please to Bates 13984?
Yes.
Can you explain what the professional fees are listed there at for the dollar amount of $13,073.66?
Yeah, again, I'm not seeing an invoice that correlates with that, but my understanding is that that's local council expenses.
You turn please to Bates 13872.
Yes.
There's an itemized amount for professional fees again for $82,899.12. Can you tell us the source of that?
Take a look. I might be getting the timing mixed up. That I can't find an invoice in the production, but that is either Georgia council fees or expert fees for FTR.
Either way, there's no corresponding invoice for that.
I'm not finding one.
To the extent that the invoices that we've gone over are what you believe to be local council fees, you were not directly supervising that work, were you?
Well, I was not in their office day to day, but we were, in communication with them, talking to them, asking them for, specific work or advice, et cetera. And then they were giving it to us or performing it, and then sending us a monthly invoice. We would look at that invoice when it came in. If it seemed appropriate, which it usually did, I think, Randall Morrison or I would put it in for a payment, and it would be paid in due course.
Those invoices were not business records of your law firm, Kelly Dry & Warren.
We did not create them.
And there's nobody from either Strickland, Lewis, Brockington, or Mr. Strickland's subsequent law firm to discuss those invoices here today, right?
There is not.
I'm sorry, I didn't catch that.
There is not.
All right, thank you. Would you turn please to Bates 14001?
Yes.
Can you explain the line item for $3,600 in professional fees on this invoice?
Let me see. I again, like the others, I don't find an invoice from a Georgia council here, but I do suspect that that's what that is.
You turn please to Bates 14008.
Yes.
And can you explain the line item for professional fees of $1,039.62 on that invoice?
I think my answer is the same on that one. I don't have a specific invoice, but I believe it's a Taylor English invoice.
Thank you. Would you turn please to Bates 14027?
Yes.
Can you explain the line item for professional fees in the amount of $1,020?
I believe that is the Taylor English invoice that you can find at Tech M 14292.
Okay, thank you. Turn please to Bates 14073.
Yes.
And can you explain the line item for local council fees of $6,370?
So on that one, I think you will find the invoice that goes with that at TechM 14289 to 14290. And so 14289, 14290. And then just happen to notice that, that invoice from Taylor English is in March. And this Kelly Dry invoice is in May. But if you look at the June Taylor English invoice that's at 14301, it notes a payment for $63.70. So it looks like it took us a little while to get the payment out, to put it in for payment. So it showed up at Taylor English sometime in May or June.
Confirm please to dates 14051.
Yes.
There's a line item for professional fees of $6,725. Can you explain that?
I'm not seeing an invoice to correspond to that, but I think it's a Taylor English invoice.
We have no record to tell us for sure that it's a Taylor English invoice, or if so, what services were performed to earn that fee. Is that correct?
Object to the form.
Sustain.
Is it accurate to say that we do not have the invoice that would tell us for sure that the $6,725 in professional fees were invoiced by Taylor English?
Yes, right.
And is it accurate to say that that we don't have any record to tell us what was done to earn a fee of $6,725?
Same objection.
Overruled. Go ahead.
Let me think about that. I think we don't have an invoice. I mean, there's well, okay, I'll agree with it.
Confirm please to Bates 14102.
141202?
14102.
I'm there.
Can you, do you have any documents that explain the professional fee of $3,000 reflected on that invoice?
I believe that is the Taylor English invoice that you find at TechM 14298 to 14299.
So that 14298 and 14299 shows a balance due of 9725. Are you saying that the 3,000 is just from the total current fees line?
Correct.
Okay. To the extent that you have testified in the last few minutes about professional fee line items that don't have underlying supporting invoices, is it accurate to say that, as we sit here today, you can't tell us what services were performed to earn the fees appearing in those line items?
I don't think I can tell you specifically on, which day somebody did, which service. But in general, I know that, the Strickland Brockland firm or Taylor English provided local counsel services in this case as requested. Pretty much on local issues, local filings, things like that. That I can say. I mean, I can't specify specifically what they did, but they did what we asked them to do, and we thought their charges were in line with what we asked.
You weren't looking over Frank Strickland's shoulder and supervising him to determine what he was actually doing, as may have been reflected on any invoices that his firm sent to you.
Could you say that again? I didn't get it.
So you weren't just looking over Frank Strickland's shoulder to determine what services he might be providing that might be later invoiced to your firm.
No, but I mean, I don't need to oversee Frank Strickland. I mean, he knows his job and he knows, how to perform the work we were asking him, and that's what I was relying on.
But he's not here today to tell us what he did or to authenticate any invoices that his firm may have issued for services he provided.
No.
You take a look, please, at Bates 13874.
Yes.
This is the first page of an invoice dated October 11, 2018, correct?
Yes.
Okay. As we move through the subsequent pages of this October 11, 2018 invoice, is it accurate to say that a portion of this invoice was devoted to work on a motion to dismiss.
Let me take a look at it.
Excuse me, counsel. If I could just take like a 3-minute break while Mr. Robin is looking at that matter, I would appreciate it. So we're going to go off the record. It is 1:47. We'll be back at like 1:50-ish. If you guys will accommodate me. Thanks.
Thank you.
Absolutely.
Absolutely.
Thank you all for that accommodation. I appreciate it. I am back, and forgive me. I think there was a question pending, so I apologize for the interruption when Ms. Meyer returns. Go ahead, Ms. Meyer. Sorry about that. Thank you.
Thank you. Always happy to accommodate the court. So, Mr. Robin, I had asked you to find Bates 13874, I think it was, and to go through and confirm that a portion of the fees reflected on the October 11, 2018 invoice are associated with work on Tech Mahindra's second motion to dismiss.
I see references to a motion to compel discovery and a motion for summary judgment. I'm not seeing a motion to dismiss. Is there a specific entry or time entries that you're thinking of?
Well, not necessarily, but do you agree, you do agree though that, that there at least was worked on the motion for summary judgment, reflected on that invoice?
Yes,
And that's the motion that, that was unsuccessful, correct?
yes.
So
Yes.
I'll tell you, I'm sorry, I didn't mean to interrupt you.
No, it was unsuccessful, yes.
I'll tell you, I did kind of a rough calculation, that it looked like about 25 hours were spent on that were billed on that invoice for the unsuccessful motion for summary judgment, and motion to dismiss combined. Feel free, of course, to go through and check my math, but does that sound accurate?
No,
It does not?
no, because I don't see anything about a motion to dismiss.
Okay. Well, what about on the motion for summary judgment? Does that number 25 hours appear to be accurate for that particular invoice?
I don't know.
Would you like to, perhaps you would like to check my math and just run through the invoice and tell me how much time you think was devoted to the motion for summary judgment on that invoice?
Suppose I can do that. I don't know. It's hard to really tell what's spent on what because the time entries are mixed. It seems like a lot of time was spent on a motion to compel the production of interrogatory responses from Mr. Belomo, and there was significant time spent on summary judgment.
So although you were not clear on the number of hours spent on the motion for summary judgment, you characterize it as significant time?
It was significant, although I think it probably looks like there was about 100 hours for the month, maybe a little more. I think it was probably, I don't know, a third, maybe less.
So maybe 33 hours during the month of October devoted to the motion for summary judgment?
Maybe.
Would you turn please to dates 13863?
Yes.
This is the invoice for November 12, 2018, correct?
Correct.
Right. And would you agree that during the month reflected on this invoice, there was also time devoted to the motion for summary judgment?
Sometime, yes.
Okay. Do you happen to have an approximate number of hours devoted to the motion for summary judgment as reflected on this invoice?
No.
Can I interrupt for a moment and ask just to sort of speed this along? I assume, Ms. Meyer, that the reason you're asking these questions is that part of your argument is going to be that if there is an award of fees, it shouldn't include things like time spent filing motions that were ultimately unsuccessful. But it doesn't, I mean, I can accept that based on the attorney's fees. I don't know that we need to spend this much time with Mr. Unless you're arguing that the time spent itself was excessive. But if you're simply arguing that they shouldn't be compensated or be able to recover for that time because it was ultimately an unsuccessful motion, I can accept that and hear argument on it about, the amounts that should be reduced. I don't know that we have to ask Mr. Robin to go in through it and do math.
Thank you, Your Honor. It is both of the issues that the court has identified, both that the motions were unsuccessful and also the large amount that is reflected on there. Perhaps there's a way to short circuit this and just ask Mr. Robin to, can you agree that there is a substantial amount of time reflected on this particular invoice from November 12, 2018, associated with the unsuccessful motion for summary judgment?
Can you ask that question again?
Would you agree that there is a substantial amount of time reflected on the November 12, 2018 invoice that's associated with the motion for summary judgment?
I mean, the invoice shows what it shows. I mean, we were spending time on lots of different streams of work. I mean, as I read this, we had to deal with Mr. Greenlee's deposition. We were dealing with, preparing an errata sheet for our 30B6 witnesses deposition. There was the summary judgment motion, and in parallel, there was, discovery disputes that are going on. And all of those things were taking up time. The summary judgment motion certainly was an important piece of the case, and we spent, the time that deserved. It was a significant opportunity to try to at least narrow the case. And since there was only one claim against Tech Mahindra, it was, could have retired the case. And we thought we had a strong motion. And so we spent time on it accordingly.
There are also references in this invoice to an A. Beal, B-E-H-L affidavit, for example, on October 12, 2018. That's Bates 13868. You see that?
Yes.
Okay. And that affidavit from Mr. Beal was associated with the motion for summary judgment, was it not?
Yes, it was.
Okay. So, you testified a few minutes ago that time entries have multiple activities all included in a single time entry, correct?
Yes.
Okay. So it's sometimes so it's difficult to parse out what portion of a time entry is for work on the motion for summary judgment versus some other work stream, right?
Sometimes.
But a significant portion of the November 12, 2018 invoice is for work associated with either the motion for summary judgment or the associated statement of material facts or associated affidavits, correct?
Or the Greenlee deposition.
But specific to the motion for summary judgment, there are time entries in there that are for the motion, statement of material facts, Mr. Beal's affidavit, and other documents that were specific to the motion for summary judgment, right?
There are time entries that cover that.
Okay. Would you please turn to Bates 13887?
I'm there.
Okay. This is the December 10, 2018 invoice from your law firm, correct?
It is.
Okay. As we go through this invoice, is it accurate to say that almost the entirety of this invoice is associated with the motion for summary judgment?
I understand that Mr. Robin wants to be cautious about reviewing documents before he responds, but I mean, I can read the document, y'all. I used to do billing. I was a defense attorney, so I had to do these bills. I know what they look like. I know how to read them. I feel like we can move past this. I myself can review it and as a third party look at it and say, yes, almost all that time. If I got real granular, I might find a couple of entries that weren't associated with the summary judgment, but almost all the time was associated with the summary judgment. Let's move on.
Thank you, Your Honor. Just one more question, if the court will permit me, about this invoice. There is, Mr. Robin, there is a series of entries regarding filing under seal and associated pleadings. Would you agree that that also was associated with the motion for summary judgment?
Can you point me to those?
For example, Bates 13892.
I'm not certain of that because there's other pieces of this that talk about a discovery dispute, and then there's this talk about AT&T. So I'm not certain that's about the summary judgment motion or not. I just don't remember.
Do you recall whether there were documents filed under seal in connection with the motions for summary judgment?
There were. I don't recall that we spent a tremendous amount of time preparing motions to seal. I remember them being fairly simple, but yes, there were.
Would you take a look, please, at dates 13986?
I'm there.
This is the invoice from January 22, 2019, correct?
Yes.
And would you agree that this invoice also contains, for the most part, entries associated with the then pending motion for summary judgment that was originally supposed to have been argued in January of 2019?
Quickly looking at it. Yes, I think that's fair. Most of them do. There's also some part of it that deals with Judge Markle's appointment to the Court of Appeals.
And that was the reason that the hearing on this motions for summary judgment had to be continued from January to a later date to allow for Judge Markle's replacement to be appointed.
Yes, but for a period of time, we weren't sure if the hearing was going to be moved or not, and so we were trying to figure that out.
Right. And so the time in January of 2019 was devoted to the only issue on the table, which was the summary judgment and when the hearing would be.
Sounds right.
Right. Last item, Bates 13866. If you would. Actually, I'm sorry. That was my last item. I don't have any other questions. We've
Okay.
already gone over them.
Anything else, Ms. Meyer? Do you mean no questions on that issue or no more questions for Mr. Robin?
If I could just have a couple of seconds to make sure. I think I have covered all of my questions for Mr. Robin. So
Okay. Thank you. Mr. Buhay?
Thank you, Your Honor. I want to touch on a couple of these invoices, but I'm not going to replow all the same ground. Mr. Robin, if you could look at page 14051. This was Ms. Meyer asked you about a charge on that page. I believe it was a $6,725 professional fee charge. Let me know when you're there. Okay, and it's my understanding your testimony is that was from Frank Strickland's firm, correct?
That's what I think it would be.
Okay.
Yes.
Can you look at page 14298?
I'm there.
And I see there a line at the a third of the way down on that page says previous balance brought forward. Well, first off, that's a Taylor English bill, correct?
That's right.
And there's a note there that says previous balance brought forward 6725.
Yes.
Do you know whether that charge is the same charge that's referenced on 14051, which was, I believe, an invoice issued around the same time or a month earlier?
I think that it probably is. I mean, dates match up. I believe so.
Okay. Could I ask you to look at page 14102?
14102. Yes.
You beat me to it. There's a charge there for professional fees of $3,000.
Yes.
And now if you look back at 14298.
Yes, I'm there.
And I see on that invoice, professional services being charged by Taylor English of $3,000, correct?
Yes.
Do you think the $3,000 charge on 14298 is the $3,000 charge that you billed a Tech Mahindra on 14102?
I do.
Okay. I'm gonna ask a couple more questions on this, and then I'm gonna if I can control the screen.
Go ahead.
Screen 2. I'm showing you what has been marked as Tech Mahindra exhibit number 17. Do you see that? Or I may not be sharing yet. I haven't
I
started
think you're sharing.
Now I'm sharing.
Yes.
Okay. Mr. Robin, you see that?
I do.
Okay. And you and Ms. Meyer had discussed earlier today, I believe it was her email at 11:51, correct? Do you recall that testimony?
I do.
And is this email that is on the screen, is that what? Tell me what this email is.
So we had talked or emailed about the idea that Mr. Palomo or Ms. Meyer wanted to have some more information in order to make a determination about whether or not what I was telling her about Tech Mahindra's involvement in an arm's length transaction and lack of culpability here was true. And I had offered to send the documents, but wanted to do it under an NDA as opposed to a protective order in the litigation. She had rejected that and wanted a protective order. And so I had responded back saying, well, we're at an early stage in the case. We have defenses based on jurisdiction. We can't get into that. We can't get into a protective order. That's just not something we can do. But here are some things we've found in the public record that we can provide to you, and they show that your judgment debtor that you've been trying to collect from, has no property that's free of a lien. It's totally liened up by Fifth Third Bank, and before that was subject to liens on all of its property by a bank called BB&T. And there's also this I see now it's called Amended and Restated Certificate of Incorporation of Avion Networks. That was this new company that had been formed that Ms. Meyer was questioning. And that document disproved or negated an allegation in the complaint. And so I was sending that to try and say, look, these are things that show that the notion that Tech Mahindra was involved in a conspiracy here is just not true. If this is enough to get discussions going, let me know. And that was my intention, was to try and get something going.
Okay.
More discussion.
Thank you. I want to show you now. Well, let me ask you this question. Let me do this. Do you see Tech Mahindra hearing exhibit 7?
Yes.
Okay. And Oh, well, let's go to 6 first. My understanding is that who directed that the offer of judgment contained at Tech Mahindra Exhibit 6 be sent?
I did.
Okay. And did you review this offer of judgment before it went out?
Yes, I mean, my recollection is that I drafted it and then sent it to Jonathan Poole, and the Jonathan Poole and Ann Lewis, made comments on it, and we discussed those, and then I authorized them to send it.
Okay. And when you drafted it, did you refer to OCGA 91168 and putting it together?
I did.
Do you have an opinion as to whether or not the letter complies with the provisions of OCGA 91168?
I believe it does.
Okay. I'm going to ask you in a minute how that offer came to be, but before I get there, I want to ask you about Ms. Meyer's response, which is at Exhibit 7. And obviously, she's responding on behalf of Mr. Bellomo, correct?
Correct.
Did anyone ever ask on behalf of Mr. Bellomo to extend the deadline within which to respond to the offer of settlement?
No.
Okay. At some point, did Mr. Bellomo receive all of the deal documents regarding the underlying transaction between Tech Mahindra and Avion Systems?
He received in post-judgment discovery, we learned that he received at least one, maybe two of them, or at least a form of them. And in discovery, in this action, he received them all.
Okay. So he got all the documents at some point in discovery in this case, correct?
That's right.
Okay. In looking at this rejection letter, there's no, and I'm referring again to Exhibit 7, there's no request in here for an extension of the deadline to respond, correct?
That's right.
And after receiving all of the deal documents, were you or anyone on behalf of Tech Mahindra ever approached about reissuing the offer of judgment for $10,000?
No.
And of course, Mr. Bellomo never voluntarily dismissed the claim that he had asserted against Tech Mahindra, correct?
That's right.
And there's talk about a special appearance. Was it ever proposed to you by Mr. Bellomo or his counsel that Tech Mahindra enter a special appearance solely for the purposes of executing a confidentiality order to produce the documents that were ultimately produced in discovery?
I don't recall that at any point.
Okay. Do you know the total amount of the invoices that Frank Strickland issued to you in this case, or excuse me, issued to Tech Mahindra in this case?
I don't know that sitting here right now. I would have to calculate that.
Okay. My understanding it's in the neighborhood of approximately $51,000. Does that sound right to you based on your experience and the work that Mr. Strickland and his firm did prior to my firm's involvement?
Yes.
Okay.
Sounds about right.
Okay. In your opinion, was filing a motion for summary judgment an appropriate tactic in this case?
Yes.
Okay. Your Honor, I'm gonna ask kind of how you want me to proceed. I'm prepared to go through all my exhibits. I don't know that it's absolutely necessary. I don't know if it's a wise use of our time. But the main reason to go through them was to authenticate them and then tender them into evidence. And I don't know if Ms. Meyer has an objection to any of those exhibits. If not, I would tender all 17 of those exhibits into evidence.
Ms. Meyer? Hang on, something's ringing, Mr. Robin. I think you're unmuted, and so we're getting weird background on you. Ms. Meyer?
Thank you. The only objection we have to any exhibit is to the portion of Exhibit 1 that that is not invoices from Kelly Dry and Warren. So to the extent that there are invoices included in there that came from Strickland, Lewis Brockington, or from Taylor English, we do not believe that those are properly authenticated. They contain hearsay. There is nobody here from either of those law firms to testify about the contents or to authenticate those invoices. And so we would ask that those not be included in the portion of Exhibit 1 that is admitted. We don't have an objection to the admissibility of the other portions of that exhibit. So to the extent that the invoices are from Mr. Robbins' firm.
Okay.
Your Honor, in response to that, what I would like to say is this: we would ask that the court admit all the exhibits subject to Ms. Meyer's objection to the Strickland firm and Taylor English exhibits.
So I have a question before I answer that question or that request, and that is this. I understand that no one is here, that Mr. Strickland isn't here to authenticate those invoices, but given that they were submitted to the Kelly Dry firm, relied upon by the Kelly Dry firm, and maintained in the normal course of their business, why would that not satisfy? I mean, granted, we don't have the original people who created it, but those are records that exist in the business records of Kelly Dry on which they relied and on which their clients relied. So I'm not sure why that wouldn't satisfy the minimum requirements for business records for authentication and hearsay purposes.
Well, Your Honor, the invoices from Mr. Strickland's firm contain entries that purport to describe work performed, and presumably those entries are offered to the court to establish that that work was in fact performed and the fees for that work properly earned. But we don't have anybody who can confirm that that work was performed. Mr. Robin has said that he didn't see it performed. He's assuming it was performed, but we don't know what was done. And there's nobody here to tell us whether that work was actually performed as documented on those invoices. And so I think that that's a separate hearsay issue that has not been resolved.
Right. Well, frequently, in my experience, when it comes to documents on which we all routinely rely in order to conduct our business on a day-to-day basis, the hearsay objection that you're raising, which I certainly understand, is essentially the same as the authentication. The same foundation would satisfy the concern. I'm not sure. Let me say this. To the extent that those exhibits were submitted, those documents, those bills were submitted to Kelly Dry to secure payment, and they were then relied upon by Kelly Dry to be submitted to the client to secure payment, I think they carry with it the indicia of reliability. But setting that aside and without ruling on that issue, I will accept Mr. Buhay's invitation to allow the admission of all those documents subject to Ms. Meyer's objection.
Thank you, Your Honor.
Thank you.
Mr. Robin, do you have any reason to believe that the invoices sent by Mr. Strickland's firm, whether his prior firm or Taylor English, were inaccurate in any respect?
No.
And if you could speak up, Philip, we got the no, but just, I think you're leaning. Same sort of question here. Do you have any reason to believe that Mr. Strickland's firm did not do the work that they reported to your firm?
No, I think they did it.
Okay. I mean, you received work product from them, I assume?
Yes.
Okay. And you spoke with them on the phone and corresponded and so forth, correct?
Right.
Okay. As the judge has noted, your firm relied on those invoices and in fact paid Mr. Strickland's firms for those invoices, correct?
Yes.
Your Honor, at this point, I'd ask that the court accept into evidence the portions of Exhibit 17 that relate to Mr. Strickland's invoices.
Subject to Ms. Meyer's objection, motion is granted. They're admitted.
Okay. At this point, I just want to go through a few background things. I think this is going to streamline my questioning a great deal. So if you'll bear with me. Mr. Robin, we haven't talked about your experience in education as a lawyer. Can you briefly describe how long you've been practicing law?
Sure. I graduated law school in 1998. I was admitted in New Jersey in December of 1998, in New York in March of 1999. I've been at Kelly, Dry and Warren my whole career. I was elected a partner on effective July 1, 2007. For the entirety of my career, I have, represented, or a large part of my career has been representing Indian companies doing business in the United States. It's something that I have, I think, specialized in. We have an Indian practice here, or an India practice group. That's one of the oldest India practice groups in the country. I'm, one of the, main litigation partners in that group. And I handle, commercial cases for those clients and others, as pretty much a huge part of my practice.
Okay. And my understanding is that the total amount of fees that Tech Mahindra is seeking in this case, I'm gonna fees and expenses. The fees are your firm's fees of $1,664,265.12. Is that correct?
That's right.
And then of the expenses, which include Mr. Strickland's fees, my firm's fees, the number there is $499,149.23. Is that correct?
Yes.
Okay. Your Honor, I think I cover it in my affidavit, but just for the record, I swear and affirm that the testimony I'm personally giving is true and correct. I've been practicing law since 1996. I've reviewed my firm's invoices and found them to be reasonable. The copies we've submitted are true and correct, and the time that was billed was accurately recorded. Going on to some of these exhibits, I don't know that we need to go over the order of dismissal or the Court of Appeals, the Supreme Court's rulings. Let me see. Here's what I do want to touch on this, Your Honor. Philip, if you could look at Exhibit 6 for me, please. This is and I've got it on the screen still, correct?
Yes.
Okay.
If you're talking about the offer of judgment itself, yes, you've got it on the screen.
Thank you. Thank you, Your Honor. Mr. Robin, if you could tell us how it came to be that the decision was made, or walk us through the decision process to make this offer.
Sure. So, I had this exchange of correspondence and phone call with Ms. Meyer about the case, early on in September. And, we thought at that point, and throughout the whole entire case, that we were not properly in this lawsuit. So, we thought, we had no knowledge of Mr. Bellomo's judgment. We had no knowledge of him at all. We believe that after looking at the public record and the UCC filings, that the Fifth Third Bank had, the entirety of, the liens to this, to Albion Systems property. And we knew ourselves that, we had just done a transaction with Albion Systems to create this joint venture, and that there had been, nothing that had gone on. And in fact, Tech Mahindra had paid money into the joint venture that actually had reduced debt that Albion Systems owed. So, this was where we were coming from at this point. And so after I had this exchange with Ms. Meyer, during which I had made this prior offer, we were thinking, this was either a mistake, and we'll, give an offer of $10,000, so, the kind of defer or, cover the expenses that they incurred, making a mistake in filing, or it's not a mistake, and, we have no place in this case, and we really want to create some downside for the plaintiff to keep us in a case we don't belong in whatsoever.
Okay. Bear with me, Your Honor. Had you earlier or at a point subsequent, well, never mind, I'm not gonna bother with that. Your Honor, I think that's all I have, unless, Mr. Robin, I'm gonna throw it to you. If you have anything else you want to add that you think is relevant for the court's consideration of this motion, please feel free, but.
I mean, the only thing I would add is that, throughout the whole case, as we went through the case, I think our rationale for the 10,000, that, we didn't have liability, we didn't know anything about Mr. Bellomo, we had no intention to harm him, was substantiated, and our feeling that we were being kept in the case, essentially because we were a deep pocket, was substantiated as we went along. I mean, it really looked as we got deeper into the discovery that the plaintiff knew that we had no liability, that this transaction occurred and was in the works long before he got his judgment, had nothing to do with him, and we were kept in the case solely because there was a potential, given the risks that happen when you go in front of a jury. We were just kept in the case because there might be, a victory that wasn't justified, and that he might, score a big win. And we didn't think that was fair, and that's why we fought. And we think till this day, as we thought on October 23rd, that we had no liability, and we were willing to pay $10,000 then, because we thought, well, we'd cover his cost up to that point, just to be nice if it was a mistake. But he chose to sort of gamble, and we don't think that was right.
Mr. Bouvet, can you take down your screen share, please?
Oh, certainly. Sorry.
Thank you. Actually, I have a couple of questions, and then if I mess up everybody's perfectly crafted questioning of this witness with my questions, you're free to follow up. Mr. Robin, because of the longstanding, in reviewing the bills, right? It's clear because there's a large discount. I would assume it's because of the ongoing nature of the relationship that your firm had with that client. And because of that, there's not a line item that indicates what your hourly rate is. Rather, I can sort of reverse engineer it by dividing the number of hours by the total billed and then 20%ing it, which, let's face it, I went to law school, not math school. So when I do that reverse engineering, I get something close to about 600 and something dollars an hour on some of the earlier invoices. It might have gone up at some point. Can you address that a little bit for me about your sort of standard hourly rate for this client?
Sure. I mean, do you mean per timekeeper or just for B?
No, for you.
If it would be okay with you, could I look it up?
Oh, absolutely. I just, here's why I asked, because when a court is considering attorney's fees, one of the factors, you have to look at that lodestar calculation if the court's going to grant fees. And one of them is to determine, I mean, if you're charging $4 million an hour, probably not reasonable. But if your hourly rate is, I think it's somewhere north of 600-ish, if I'm doing my really quick math correctly.
So So we started in 2017. So my regular rate, the rate that would be undiscounted for 2017 was $740.
Okay, so see, this is why I don't do math. And then it looks like Mr. Morrison's rate was somewhere north of 400.
I can look. Would it be okay with you if we went through all of mine for all the years and then moved to each person?
Oh, yes, sure, absolutely. If you can honestly just give me a range, if you can tell me in 2017, it started at 740 an hour, and then by the time this litigation was concluded, it was at whatever number.
Sure. So it was 740 in 2017, and in 2023, it's 965.
Okay. And what about Mr. Morrison?
I'll look up Mr. Moore.
Sorry, Mr. Buhay, did you have a question?
I did not. We touch on some of this, Your Honor, and I was looking at the exhibits, then Mr. Robbins' affidavit, like at Exhibit 9. There's, I think it's subparagraph 8, talks about the discounted rates from being $555 to $700 for partners and $348, $75 to $580 for special counsel and associates. So it's a range again, Your
Right.
Honor.
And that's fine. I just wanted to make sure I had an understanding of what that was. Mr. Robin, would you agree with me that the cost of attorneys generally, and certainly attorneys with your level of expertise relative to Indian companies that are dealing significantly with Indian business interests, is higher than it is in Atlanta for the local counsel that you retained?
Oh, higher, I suppose, the rack rate, yes.
Right. Yeah. And I'm not asking you to opine on how much it should be higher or whatever. I just generally, you would agree with me that it's a higher rate. On many of the invoices that I reviewed, there's a line item when we're talking about the expenses that have been requested. There's a line item that says discovery costs. Can you tell me what that is in reference to, what that, and you can pick an invoice and use it as an example and explain it to me. That's totally fine. I'm just trying to understand, like, I feel like I have a good understanding of what professional fees means anytime I encounter it on your bill. I'm not sure I have a clear understanding of what discovery costs that line item means on your bills.
Those are costs associated with e-discovery, so hosting documents, relativity charges, the management of the data and manipulating it, producing it, those types of fees.
Okay. Okay.
I have Mr. Morrison's rates, if that's of interest.
Yes, please.
So in 2017, which is his first year with us, although not his first year as a lawyer, his standard rate was $465 an hour. And this year it's $845.
Okay.
Can I ask a question, Your Honor?
Yes, sir.
Mr. Robin, so if Mr. Morrison's rate was $465, was it discounted by 20% on all the bills?
Yes.
Okay, so that'd make it roughly, I don't know, I'm 375-ish, 370 an hour effective rate for this case.
It was for 2017 it was 372.
Okay. And Your Honor, while we're here, I'll just state, and this is stated in my exhibit number 18 in my affidavit, just so we're clear. My hourly rate and the hourly rate my firm's partners charged in this case was $495 an hour, which is fair and reasonable based on my experience in the Atlanta market. And I will say this. The only other two lawyers in my firm who worked on this case were George Green, who assisted with some pretrial stuff, and my partner, Gary Toman, both of whom, Gary's been practicing over 30 years. George has been practicing approximately 15 or so. Both of them, their rate was $495, and I kind of supervised their work and found all their work reasonable and necessary.
Okay, and to be clear, I do not mean to, I don't want anybody to interpret the reason for my questions to be that I question that Ms. Meyer, Mr. Buhay, Mr. Robin, Mr. Strickland, Ms. Lewis, anyone else who worked on this. I actually think I know many of you personally, and if I don't, I've seen you involved in this case and find y'all to be highly competent and capable. And I'm not concerned about the hourly rate as much as if the record is to be made, as I understand it, if I do grant fees, I have to make a finding that the hourly rate, whether it's the discounted or the rack rate, as Mr. Robin referred to it, is a reasonable rate under the circumstances and the amount of work that was billed, that the work itself was reasonable and that the amount of work that was done was reasonable. To that end, Mr. Robin, and I'm going to key in on this, and this may invite more questions, but just to sort of, in the interest of full disclosure, to let you know what my thoughts are. One of the issues that Ms. Meyer has focused on in much of her briefing is the fact that a substantial portion of the discovery she was ever able to get regarding Mr. Bellomo and the transactions ultimately had to be gotten from Tech. And I think it's because you guys were the custodian of a lot of the records because you purchased one of the divided entities. And so one question I do have is, to what extent, if I asked you to, could Kelly, Dry, and Warren identify the amount of time and money in fees that were spent producing documents that Mr. Bellomo could have obtained by subpoena to a non-party on TechM? Or that TechM would have functionally been responsible for responding to because of its control over one of the subsidiary entities, one of the Avion entities?
We could probably estimate the cost that would have been involved. I think we could estimate the cost. The former, I think.
Okay, and I understand I'm putting you on the spot.
Yeah.
I just, obviously there was a great deal, the scope of discovery, because you were a party, was much broader. But I think Ms. Meyer's point, to some extent, is probably well taken in the idea that there's a great deal of work that Kelly, Dry, and Warren would have had to do on behalf of TechM because this litigation existed, even if they weren't a party to it. And so I'm trying to figure out how to calculate that if the court is inclined to grant fees. So,
I mean, we could probably estimate it. I don't agree with her premise, though, because there's a lot of difference between, responding to a subpoena as a non-party and producing documents and dealing with a case where, someone's seeking damages and punitive damages and all of that. I mean, it's a different level of risk.
oh, I completely understand and don't disagree with you. I just wanted to inquire on that issue. Now, those were the only questions that I had. But if that makes everybody else have questions, Ms. Meyer, if you have any additional questions for Mr. Robin.
So Mr. Robin, to add to what Judge Krause just asked about potential response to a subpoena had Tech Mahindra not been a party, would you agree that it also would have been necessary for Mr. Bellomo, through me, to have taken depositions of Tech Mahindra personnel, including but not limited to Tech Mahindra's 30B6 witness?
I don't know. I mean, that may or may not have been the case.
And that was a deposition of Mr. Iyengar that Tech Mahindra required me to travel to Texas to take, correct?
Well,
Is that a yes?
I mean, I don't agree with the word require. That
I was going to say, it's an argumentative question. I don't know that it matters for anything, but did in fact Ms. Meyer travel to Texas to take the 30B6 deposition of Tech N?
Yes.
Okay.
No other questions for Mr. Robin. Thank you. And I
Mr.
don't have any questions for Mr. Buhay.
Thank you. Mr. Buhay, any additional questions for Mr. Robin?
No, Your Honor. Again, I'll throw it out to Mr. Robin if he has anything else that he would like to point out as counsel for Tech M in this case.
No, nothing from me.
Okay. Ms. Meyer, do you have any other witnesses that you want to call?
No, Your Honor, but I don't think I tendered my exhibits, and I would like to make sure I've done that.
Of course.
Plaintiffs 1 through 8.
Any
No
objection?
objection. No objection, Your Honor.
Thank you, Mr. Buhay. Those exhibits are admitted.
Your Honor, we have no other evidence. We would like an opportunity to do a closing presentation.
Okay. Mr. Buhay, any evidence you wish to put on, sir?
No, Your Honor.
Okay. Well, then we are concluded with the evidence that's going to be presented to the court. And so I'll now hear Ms. Meyer, it's your motion. So what I'll do is call upon you. If you wish to go first, you will get an opportunity to respond since it's your motion. So I'll call on you and then hear from Mr. Buhay and then let you respond. Go ahead.
Thank you. Thank you. So there are two issues, of course, as the court is aware. One is good faith and one is the reasonableness of the fees claimed. With respect to good faith, the case law says that there are 3 factors for the court to consider. First of all, whether the offer bore a reasonable relationship to the amount of the damages. Secondly, whether the offer was premised on a realistic assessment of liability. And third, whether the offeror lacked intent to settle the claim. And I cited, of course, the cases for that in my brief. With respect to the first factor, reasonable relationship to the amount of the damages, I think it's pretty clear that when there's an offer of $10,000 and the judgment that's a liquidated damage is for almost $305,000 plus post-judgment interest, that there's a great disproportion between the amount of the offer and the amount at issue. And of course, that doesn't even factor in punitive damages and attorney's fees. In this case, since civil conspiracy is legally indivisible, if Tech Mahindra were to take a hit in the case, its minimum exposure was the full $305,000 plus the post-judgment interest, even if there was no award of the fees and punitive damages. So $10,000 versus $305,000, it's less than 3%. Even lawyers who don't do math can probably almost accurately calculate that percentage. With respect to the second factor, reasonable assessment of liability, and this goes to the point that the court has already acknowledged, which is that Tech Mahindra had all the documents. And I was asking to see the documents, and Tech Mahindra didn't give us the documents until months after the deadline to respond to the Rule 68 letter. And so we're asked to make a decision about this tiny offer that's out of proportion to the amount at issue when we don't have the records in front of us to evaluate liability. But meanwhile, Tech Mahindra has everything. They've got all the deal documents, they've got all the drafts of the deal documents, and they've got all the emails discussing the various items, including, for example, due diligence regarding pending litigation, which would have included Mr. Bolomo's then pending lawsuit against Avion Systems. So Tech Mahindra had all of that. We didn't have any of it when they put that offer on the table. And then the other thing that is significant is that Tech Mahindra, although Mr. Robin claims Tech Mahindra was trying to be an open book, when I asked to see the documents and said, I'll give you confidentiality, his answer is, well, I can't give you a confidentiality order. I can give you an NDA, that's going to require you to come to New York or New Jersey or somewhere else to litigate over it if there's an issue. You're going to have to sign off and be personally liable, subject to jurisdiction in some other state if there's an issue under the NDA. But I'm not going to give you a confidentiality order because I don't want to waive personal jurisdiction. But of course, I'm sure the court is quite familiar with the concept of a special appearance to assert a personal jurisdiction defense. It's done fairly routinely by parties in Georgia courts, and there would have been an opportunity for Tech Mahindra to have negotiated a confidentiality order for us to then have entered by the court, with Tech Mahindra doing so by special appearance. Ultimately, that's what happened in 2018. It just didn't happen in time for me to receive documents and evaluate them in the context of the Rule 68 offer. So when Tech Mahindra says, well, we gave you what you needed to see, and you could have made a decision about liability in the time it took to respond to this Rule 68 offer, that's not actually the case, because we didn't have all the 13,000 documents in front of us. And Tech Mahindra didn't agree to give us those 13,000 documents and didn't agree to enter into a confidentiality order so that we could see those 13,000 documents before the Rule 68 offer expired. And then the other key thing about the timing of the Rule 68 offer is that it comes out almost immediately after Judge Markle stays discovery, which means that Tech Mahindra knew or should have been able to calculate that it's sending a Rule 68 offer without giving us records in a time frame that is going to prevent us from engaging in any discovery to evaluate that offer, or the offer expires. So that's the significance of when Judge Markle stayed discovery in relation to when that order went out.
I will say it is a little weird. I mean, when I review the record, right, that whole order of stay until I rule on the motion to dismiss doesn't even make sense to me, because I think the record shows it was entered on the 19th of October. And then the actual order denying the motion to dismiss was entered on the 23rd. But if you look at the actual document, it was signed on the 17th. So the record seems to indicate that Judge Markle actually denied the motion to dismiss, which would obviate the need for a stay before he ever entered a stay that was then lifted 4 days later on the 23rd. So, but I mean, I understand your point, Ms. Meyer, but it is a little confusing. It's a little wonky.
The timing on a few things is a little bit confusing. I agree. But I think the key thing here is that this discovery was stayed right before this Rule 68 offer went out. And that seems like an unusual coincidence. I don't think it's a coincidence. I think that was part of Tech Mahindra's strategy. Which brings us to the final factor with respect to good faith, and that is Tech Mahindra's intent in making this offer. And Mr. Robin has testified to what he contends their strategy was, that this was some effort to be nice to Mr. Bellomo, pay his early fees and get rid of him. I'm always appreciated when a corporate defendant wants to be nice to the little guy. It's always a little bit of a surprise when I hear that. So maybe that's really what Tech Mahindra was trying to do, or maybe Tech Mahindra was trying to intimidate Mr. Bellomo, the little guy, into accepting a lowball offer in the dark without giving him any basis to make an informed decision, or giving me any basis to make an informed recommendation to Mr. Bellomo. Or maybe the idea was just to create a paper trail to hang something over Mr. Bellomo's head, to try to get him to walk away before he actually saw any records, any of those 13,000 pages of records. So So again, we have an offer that was out of proportion to the amount of damages, an offer that was not premised on any realistic assessment of liability, and the party that made the offer was the only one that had all of the records. And then it appears that there was a lack of real intent to settle a claim for what it was worth. Then we get to the reasonableness of the fees, and the court has already noted the various factors that come into play, such as the complexity of the case, the levels of experience of the counsel, the typical hourly rate for attorneys of similar experience in the metro area, not the New York area. Here we've got fees that are fees and expenses that are more than 8 times Mr. Bellomo's judgment. I got into some of the fees related to the motion for summary judgment and the second motion to dismiss that were filed in tandem. Excuse me. And I didn't ask Mr. Robin to do all of the math as we sat here today, but I will tell you that when I went through those invoices for October, November, December, and January, October, November, and December of 2018, January of 2019, what jumped out at me was that, excuse me, the fees associated with the motion for summary judgment and the second motion to dismiss that was filed around the same time collectively came up to about $400,000, which exceeds the amount of Mr. Bellomo's judgment against Avion Systems, as well as the post-judgment attorney and post-judgment interest that had accrued as of the date that motion for summary judgment was filed. And so, and of course, the motion for summary judgment and the second motion to dismiss were not successful. And so not only is that out of proportion to the amount at issue here, but it also, it tells us that Tech Mahindra viewed Mr. Bellomo's claim as worth at least $400,000. Otherwise, why spend that money on a motion for summary judgment? It also tells us that if Tech Mahindra was serious about resolving this case, why didn't it put $400,000 on the table to Mr. Bellomo rather than, or even some portion, half of that even, rather than putting $10,000 on the table to Mr. Bellomo? Why spend so much money on a motion for summary judgment in a case in which there's no liability? And of course, it was not a successful series of motions. And so there is the issue of whether Tech Mahindra should really be reimbursed for filing unsuccessful motions. It's also an incredibly high amount of fees to charge for a single motion. Your Honor, in all my years of practice, I wish I could have justified billing a client $400,000 for a single motion or set of motions. And then that brings us to another point. And as the court is aware, I'm the only attorney for Mr. Bellomo. Although I'm flattered to see that Kelly Dry felt the need to put multiple billers on this file, I'm somewhat mystified that it was deemed essential to bill Tech Mahindra $1.7 million in fees to defend against a case brought by a single attorney. So I find it flattering, but that seems like an excessive amount to invoice a client for defending against a single claim. And Tech Mahindra did choose to have multiple billers work on the case, performing seemingly identical tasks, as the court may have already determined looking at the invoices. And so it's not clear whether that's padding the file or just a need to have lots of different opinions about a whole bunch of different matters. But it's an awful lot of fees and an awful lot of billers for a single claim brought by a single attorney. The court has already asked Mr. Robin about hourly rates for himself and for Mr. Morrison, but there are a whole bunch of other billers listed on Kelly Dry's invoices, and all we know about those people is their names. We don't know whether they're attorneys. We don't know how long they've been practicing. We don't know why they were brought in on the case. We don't know whether they have particular expertise. We don't know how long they've been practicing. We don't know anything about those people, and yet they also invoiced for time. And Mr. Strickland and Mr. Buhay are both talented, experienced attorneys. And they served as local counsel and could have handled, either of them could have handled this case by themselves without a need for Kelly Dry to be in the picture. And so it's not clear why there was even a need to have a New York law firm billing $1.7 million to defend this case here in Georgia when there were perfectly skilled attorneys here in town who could have handled that work. And finally, there are a couple of other items in here that make no sense to me in terms of why they are included in the fees. Looks like approximately $435,000 was devoted to post-dismissal appeal work. My understanding of the case law is that only the work performed at the trial court level would be appropriately considered by this court. And then there's also $70,000 associated with filing this fee petition. And that was invoices in May and July of this year. Again, I don't think I've ever billed a client $70,000 for a single fee petition. I'm envious. I wish I could do that. But again, it doesn't seem fair that that's something that Mr. Palomo should be charged with.
Ms. Meyer, quick question.
Yes.
You mentioned that you did not believe, you believed the case law said that the appeal work could not be recovered. Do you have a citation you can direct me to? I mean, I'm sure I can find some if that's what the case law says, but.
I realized as I was saying that I did not write down the case site, and I apologize for that. I'd be happy to look that up and get it to the court if you would like for me to do that.
That leads to my next question, which is there so I may be confusing Florida law where I practiced and also federal law, but I thought there was case law that said you could not get fees for getting fees. Am I don't know the answer to that off the top of my head. And there's a difference between entitlement versus litigating the amount. But I thought there was a distinction on that issue, to your point about the fee motion.
I think that is also correct, Your Honor. And finally, the court also alluded to this in some questions. Even if we had agreed to dismiss Tech Mahindra in exchange for a $10,000 de minimis payment, Tech Mahindra's involvement in this case would not have been at an end, because the only way we could obtain the 13,000 and so documents that we needed to see in this case was from Tech Mahindra. We obtained almost no documents from the Avion defendants. And so we would have had to have subpoenaed those documents from Tech Mahindra, even if there had been a resolution. And I'm guessing that there would have been significant motion practice over Tech Mahindra's perhaps efforts to resist such a production. And so there would have been time and expense devoted to that whole process. Additionally, we did take the 30B6 deposition, a long full day deposition of Tech Mahindra's 30B6 witness, and it would have been critical that we take that deposition because that was the person who had a significant amount of knowledge and was able to authenticate important documents. And that was all work that would have been essential to our prosecution of this case against just the Avion defendants, even if we had allowed Tech Mahindra out. And so that's work that Tech Mahindra would have had to invoice for, that Tech Mahindra, I'm sorry, would have had to pay attorneys for, even if there had been a settlement with Tech Mahindra. So bottom line, we contend that the evidence does not support the Rule 68 offer having been made in good faith. If the court were to conclude that the offer was not made in good faith, then that would be the end of the court's analysis. If the court were to conclude that the offer was made in good faith and decide to award fees or expenses, then we would ask the court to substantially reduce the amount to be awarded below what Tech Mahindra has actually asked the court for. Thank you.
Thank you, Ms. Meyer. Mr. Buhey?
Thank you, Your Honor. Look, let's start from the beginning. Tech Mahindra made a $10,000 offer. Mr. Bellomo rejected it. Tech Mahindra won in the case. So under 91168, it's entitled to recover its fees unless Mr. Bellomo, who has the burden of proof on this, can show that the offer was not made in good faith.
Well, forgive me for interrupting, Mr. Buhey.
Yeah. Yes.
Well, let me save you some time.
Yeah.
I believe that this offer was made in good faith.
Thank you.
And was a valid offer that was rejected. And therefore it is enforceable. I don't think I've made it a secret in terms of the questions that I've had, that my real concern here is the nature and scope of what a fee award would look like. I will, and so I'll save you the time by asking you to sort of focus your efforts there, because, for example, one concern I have is to make sure that I'm comfortable in my ability to draft an order that is legally defensible, that says 91168 requires the following, and I find that those things exist. And therefore, I think that the defendant Tech M is entitled to recover some of their expenses and attorney's fees. What I'm less clear on is, within my discretion, to what extent do I have to specifically account, or can I make a judgment call? Can it be squishier than that, or do I really need to go through every single bill and say, because I don't want to, in case that's not clear. I definitely don't want to have to do that. Not only because I don't want to do the work, but because I don't have, although I certainly understand Ms. Meyer's point that this was a lot of work, an aggressive position and an aggressive defense that Tech M undertook. I don't necessarily have a concern in the overall scheme, which is, I believe the law allows me to look at it holistically. I don't have a concern that the work, based on the defense that Tech M chose to undertake, was necessary, was probably reasonable, with a couple of exceptions. Number one is a few exceptions. Number one is what I said a moment ago about whether or not there is case law that would prohibit Tech M from recovering appellate attorney's fees and recovering fees incurred in trying to get its fees. That's one concern. Number two is whether or not, obviously I understand that Tech M is entitled to the attorney of its choice. And I also do not question that Mr. Robin and the Kelly Dry firm have highly valuable, specialized knowledge of the specific business universe in which he was working, in terms of businesses that are operating out of India and South Asia. However, I'm not entirely sure that even if Tech M is entitled to counsel of its choice, that the court is required to compensate Tech M for that increased dollar amount beyond what would be reasonable and necessary in the market in Atlanta. That's my second concern. And my third one, I made it very clear with my question to Mr. Robin, which is this. It's clear to me that there is some discovery that absolutely Tech M would have had to engage in as a non-party in order to respond to valid non-party requests that were provided to Ms. that were served by Ms. Meyer. As a result of the fact that TechM purchased one of the subsidiaries, and was the custodian of a number of the records that ultimately ended up being necessary. And so on the first 2 points I've just made are a little squishy, but on the third one, I'm very clear that I think that there needs to be an accounting for the discovery that the attorney's fees that TechM absolutely would have incurred regardless of their role as a party in this case. Now, I think Mr. Robin made a valid point earlier. I don't mean to imply that the full breadth and scope of the discovery that TechM had to engage in terms of responding to interrogatories and requests for production and any discovery practice that there was and things like that, that wouldn't necessarily have been required. But certainly responding to a subpoena at this level, producing a 30B6 witness, preparing that witness, those are all things that TechM would have had to do even if they weren't a party. And so that's where I'm going. But the easiest way for me to get there would be like, you know what? I think your fees overall were reasonable, except to the extent that I think there should be some reduction in attorney's fee hourly rate for what would be reasonable in the Atlanta market versus reasonable in the New York market. And because I think some of these other things should be reduced, the easiest thing for me to do would just be to reduce it by a dollar amount or to reduce it by a percentage. But I don't know if that is appropriate in an order to the court. I don't want to get reversed from the Court of Appeals because I just went, it feels like I'm going to reduce it by 10%, or it feels like I'm going to take off 30%.
Your Honor, I don't know how to answer the last question because I don't know the answer to the last question, which is the extent you have the discretion to, I don't want to use the word arbitrary because I know you wouldn't do it arbitrarily. You would look at it, and I mean that sincerely. I mean, you would look at it, and it does sound kind of funny, but you would look at it and exercise your judgment. You started out today by making a statement that I readily agree with, that you are an expert in your own right on determining reasonableness of attorney's fees. Anyone who's done this for any amount of time, and we all have, is able to look at an attorney's fee invoice and kind of have a good feeling, generally speaking, as to whether or not the rates or the amounts or whatnot are reasonable. With trying to address each of your points, the first point now escapes me. The second point was about the market rate.
Right. The first point is whether there's case law that says that would inhibit or that would preclude TechM from recovering fees related to the appeal, absent some further effort to settle the case, some further offer, and whether TechM is precluded from recovering fees spent trying to recover your fees.
I am unaware of any law in Georgia that prohibits a court from awarding, as part of its fee award, the appellate costs incurred by the unsuccessful party who rejected the offer. I've not seen that anywhere. I mean, Mr. Robin has spent some time on this. I don't know if you've seen anything like that, Phil. That would have been something that had percolated up to the forefront of our mind.
I feel like if there was, it would be something that we'd all be fairly have figured out by now. But I wanted to throw that issue out there. Yeah,
I'm not aware of that at all. With regard to the second issue, the market rate, obviously Mr. Robbins talked about, the 20% discount on their rate. When you discount those rates, obviously, Mr. Morrison's rate and Ms. Meyer made a point about who those other people were. Well, most of them, I believe, were associates. And so the associate rate is going to be $372, which in the insurance defense world seems high. I'll tell you, Your Honor, we have associates on insurance defense cases that bill north of that.
Yes.
And in a commercial world representing corporate clients, that is not low for the Atlanta market. My hourly rate for commercial work of this nature is actually lower than what I would quote right now. The number I would quote right now would be in the sixes. And I believe Mr. Robbins' rate with the discount comes into that. So I don't I'm not, from my perspective, I think the rates that Kelly Dry charged in this case with regard with the discount meet the Atlanta market. Regarding the discovery, you know, we've touched on some of the key issues here. I'll say it again, when you are answering discovery or helping a client answer a subpoena, you approach it a lot differently than when your client is a defendant in a lawsuit accused of conspiracy and threatened with punitive damages. So I don't know how more to address that issue than to say what we can do is go through and supplement our motion with a breakdown of the invoices. And Philip, I'm going to defer to you on this. I believe we can go and look at the discovery and then explain to you what those charges were, itemize those charges. You know, well, I don't want to step out of my lane here, but hopefully there's a way where we can put all the discovery charges in one document and total it up. And then I'm sure we would have an argument as to why that number would have been much less had we simply been responding to, you know, for instance, if Mr. Belomo had sought in post-judgment discovery in his judgment case against Avion Systems, this information, obviously TechM would have been compelled to reply under a subpoena. And I think we can make a good faith argument as to why that number in a post-judgment setting would have been a lot lower than it actually was in this case, where we're, you know, threatened with punitive damages and other damages, if that makes sense.
And I don't agree. I don't disagree. Let me correct myself.
Thank you.
I don't disagree with that assessment, which is, you know, I mean, I understand the different nature of relating to a party who is asking for, even if you believe it's burdensome, discovery from you when you are not subject to the risk of a judgment against your company individually, and particularly the threat of punitive damages, versus dealing with someone who is just saying, please give me documents, even if you think that those document requests are excessive. But all of that goes to that larger point, which I need to look at it as well, is the extent to which, if the court is going to reduce the fees that have been requested by TechM, if there is an obligation for me, I mean, it's certainly, I would provide all of what I'm saying now. It would be the justification for why I would reduce the amount of any award from what was requested by TechM. But what I don't know the answer to is the extent to which I need to make specific reductions, or if I can make broad-based reductions.
What I would suggest, Your Honor, why don't we research that? And when I say we, I mean Ms. Meyer and TechM's lawyers, and maybe give you some supplemental briefing on it, on what we think you can and cannot do based on the current state of the case law.
Yeah, I think that would be helpful. And mainly I asked because the most recent time I did this, it was a little easier because it was like a $3 million fee award, but it was a contingent fee award,
right,
stacked on top of a 9/11/68 offer of judgment. And so it was a little easier to just sort of pick a number out of the air that felt right. And this seems like a case where I'm comfortable doing that, but I feel like maybe I want to know if that's the appropriate approach within the clearly wide discretion that the court has in determining what are reasonable attorney's fees. So,
and I completely agree. And we want to make sure that you are on sound footing with whatever you do.
Okay.
And I think it makes sense for the lawyers appearing before you to provide you with supplemental briefing on that, so that we don't burden Your Honor or Mr. Freehoff with going down that rabbit hole.
Okay, so here's what I would like for the parties to do. I'm telling you now that I am ultimately going to enter an order that says that Tech M is entitled to recover fees as a result of the October 23rd, 2017 offer of judgment in the amount of $10,000, which I believe was a valid offer that contains all the necessary statutory requirements and was made in good faith. It was not accepted, and therefore the judgment that ultimately resulted, which was zero, is statutorily satisfies the requirements to award attorney's fees. The amount of those attorney's fees based on those three matters, or actually four, just to make sure we're all clear on what we're working forward on. The amount of those attorney's fees is what the court would like some additional guidance on. Specifically, Ms. Meyer, she might have been speaking off the cuff, but if there is some case law, I would love to know about it. Number one, whether there is case law that limits the ability of a party to recover under 9/11/68 for attorneys' appellate fees and expenses. Number two, if there's any case law that limits the right of a litigant to recover under 9/11/68 for the fees incurred in getting their fees. Number three, I don't know if there's any additional research I need anybody to do on this, but I will point out that one of the reasons that I would consider reducing the charge, the amount sought, as I mentioned, is whether or not I believe that there is case law about the market rate being tied to the market in which the litigation occurs, and that to the extent that the client chose to incur additional fees outside of that rate, that may or may not, that it's within the court's discretion to determine if that's recoverable. Mr. Buhay, I certainly understand your position that even at the top end, that wouldn't be outside the realm of the Atlanta market for this type of work by somebody with Mr. Robbins' experience or Mr. Morrison's experience. Totally understand that. That's a factual issue that I'll consider. But I would like to know what the case law says on that issue.
Yes, Your Honor.
And then the fourth one was, what is the nature, if the court is going to reduce the amount offered, is the court required, as it is in certain other instances, right? We all know there's lots of Court of Appeals cases that say, if you're going to enter an order that does X, you have to make XYZ findings of fact. And so what I'm interested in is, if I'm going to enter an order that awards attorney's fees, but reduces the amount that the attorneys have asked for, if I can, in my discretion, reduce it based on the amount that feels right, which I know is not the right word we're looking for, but I am the one who has reviewed the bills, who has heard the testimony, who has observed the attorneys. And so there is a wide amount of discretion. If it's an abuse of that discretion for me to simply say, I hereby award X dollar amount based on these reasons. Or do I have to say, I reduce the hourly rate by X, I will not award these items, those sorts of things, which I can do if I have to, but I'd rather not. And to the extent that you feel the need to make your record and you would like to file those as motions, feel free to do so. To the extent that you are comfortable sending to me as letter briefs, you can do that as well. But either way, if you will please make sure that when you file it, you email what you are filing to Mr. Freehoff. And because this is more of a help out the court analysis type thing, I don't know that there necessarily needs to be you file this first and then you get to respond. So if both parties, today is Friday, would it be unreasonable for you guys to do that by next Friday, which I think is the 5th? Wait, is it? I don't know what day is the 15th.
The 15th is next Friday.
Yeah, the 15th of September. Would that be
Your
unreasonable?
Your Honor, I have a mediation that day.
Okay.
And so Thursday and Friday are going to be pretty well tied up with that other case. So if I could have to the following Monday.
That's fine with me if that's okay. And again, I'm really not looking for anything. I don't need a treatise. Just a basic sort of anything, any case law that you're finding on these issues. And then I think it would also be helpful, Mr. Buhay, if it's not too much to ask, along with that issue, if you want to go ahead and draft a proposed order, that at least gives me a framework to work with, given that I've told you I'm going to grant the attorney's fee request. The issue is a motion. The issue is the amount of that I will enter.
Yes, Your Honor, and we will submit that. Well, first we'll prepare it. We'll share it with Ms. Meyer, and then we'll intend to submit that by the, I'm looking at my calendar, 18th.
That would be great. And the order, if you could please make sure it's in Word format so I can.
Yes,
edit.
and I'm not going to file it. I'm just going to send it to
Right.
Mr. Freehoff.
Just email it to Mr. Freehoff.
I learned my lesson yesterday. So
Anything else? I know Mr. Buhay, I'd said you could respond, and then I totally hijacked your response and stepped all over it. So I apologize, but is there anything else that anybody wants to make part of their record, or any other questions or concerns they have for the court?
we were touching on, Your Honor, and I didn't hear you just mention it, but would Your Honor want us to go and look at the discovery costs that we incurred and submit like some sort of detail of that as well? Just by discovery costs, I mean responding document production and the 30B6.
Well, let me say this. I don't think I need that, and here's why. Two reasons. One, I'm comfortable in my ability to review the invoices that have been submitted and develop an understanding of the percentage, the ratio, the proportion of time that's spent on these discovery matters. I feel comfortable interpreting them in that way. The only reason that I might ultimately need a breakdown like that is if your further research indicates that in order for it to be a legally valid order, I need to be able to specifically delineate dollar amounts, in which case I would need such a breakdown to be helpful to me to make that sort of reduction. I think that the larger answer is going to be that it is within the court's discretion to make a reduction across the board. But it may be that there's case law that says, but maybe that's not best practice. So we'll see. We'll see what the case law says.
I don't know. It's funny. I don't recall seeing this specifically. I mean, I think about when I've been the plaintiff in a commercial case and recovered attorney's fees, and you say they're X, and the jury gives you a number, and there's no explanation.
Right.
I'm guessing the burden is a little higher on the court than on the 6 or 12 souls who had the misfortune of being on one of my juries. But
Well, and Mr. Buhay, I think that goes under the heading of the less said, the better, right? I have learned from experience that the less I say in my orders, usually I'm better off that way. So
Yes, Your Honor. Yes, ma'am. Yes,
Ms.
ma'am.
Meyer, did you have any other questions or concerns? Anything you wanted to raise or make sure to bring to my attention on these issues?
No, Your Honor, I think I understand the court's rulings. We respectfully disagree, but we understand what the court is saying.
Okay. Thank you all for your time and effort. I will look forward to that additional briefing a week from Monday on the 18th of September. And I will endeavor to get you a ruling as soon as I can thereafter, so y'all can take whatever action you feel necessary. Mr. Buhay?
One last point, Your Honor. It's not relating to this case per se. My secretary has been out, and so I got to learn how to file, and I didn't do a very good job of it. And Mr. Freehoff was kind enough to put me in contact with whoever whatever the clerk's filing division is called. And I spoke to the deputy director of the civil division, Al Clark.
Yes, Al Clark is the man.
phenomenal.
If you have an issue with filing, he's a good man to know.
He is a phenomenal human being, and I just wanted that on the record. The county is fortunate to have him, and yeah, he's a great person and incredibly helpful.
I see Ms. Meyer nodding.
That's a point on which Mr. Buhay and I can agree. Yes, he's going to be on my speed dial every time I have a problem with the phone clerk's office from now on.
Well,
I know. I feel bad that I've got his phone number because I may wear it out. But
Well,
He's great.
I will say that the court absolutely agrees with you. Mr. Clark is a gem, and the clerk's office is very lucky to have him, as is the court. And I can't think of a better way for us to resolve this hearing than finding something on which we can all agree.